Welcome back to Kitchen Court Cases, where we watch court in my kitchen. Now, this is one of my favorite judges. She has quickly become Judge Y'all, and I think you guys will see why. This is not even, yeah, Judge Y'all. Interesting in terms of court, the way we normally see it, but she is a really great teacher and an explainer of how things work, and I think this is worth watching. So let's take a look at Judge Y'all going over some pre-trial stuff with a pro se um, litigant and one that is represented. All right, and this is in Austin, Texas. Okay? Thanks, guys, for coming to the kitchen. Let's get cooking.
Thank you.
Thank you.
Good afternoon, everyone. My name is Judge Holmes. Please give me a thumbs up so I know my audio is coming through clearly for everyone. Okay, fantastic. Well, thanks for being here. This afternoon, we're just here for what's known as a pretrial motion. So I know that we are scheduled for a final hearing on this matter. It is going to be we've got a jury trial coming up, and we are scheduled for that on April 28th. So we have almost a full 30 days before the jury trial is set. And counsel for defendant, the Webbs, Robert Webb and Laney Webb, filed what's known as a motion in limine, and he's asking to have certain things decided on before trial. And motion seems warranted, but I wanted to review it with both parties. I know, Ms. Nelson, you're pro se, so you'll be representing yourself, correct?
Yes.
Not a problem. You don't need to have an attorney to come to court and do this, so no worries about that. And Mr. Dunn, you'll be here on behalf of the defendants that day.
Yes, Your Honor.
Okay.
Actually, Your Honor, one of my associates will be here on that day. I'm leaving April 7th for another firm, but another associate from our firm will be there.
Oh, all right. Well, good luck to you in your next practice, sir.
Thank you.
All right. Well, today we're just going to review the motion in limine. I'm going to go over kind of what it means. Ms. Nelson, you can ask any questions we have. We'll just review that. Ultimately, we're just going to let y'all know what's going to be admittable, what some rules are for when we get to the jury trial, and then you'll be all set to go for it. All right?
Okay.
Okay. So I'm going to share my screen so that you can see the motion that the defense counsel made. And Ms. Nelson, do you actually happen to have a copy of that nearby?
Yeah, it's in my email.
Okay,
But
no worries.
I'm on my phone, so.
Not a problem. We understand that. Well, we're going to review it. You just make sure you have a copy that you can refer back to then. I think most of this will probably make sense as we go through it. So, okay, now I'm screen sharing, and hopefully my screen sharing bar isn't blocking anything. But this is his motion in limine. And so what he's asking, this is Ms. Nelson, that's a motion made before a hearing. So the idea is that we would have this discussion outside the hearing of a juror or the jury, or things that need to be done before the case begins. So that's all that Latin means. And really the heart and soul of it is this section over here. The first part is pretty much admonitions of things that we cannot do. You shouldn't call witnesses that we haven't disclosed, although the idea is that you want to give notice to both sides. So for example, if Mr. Dunn wants to call an expert witness, they need to tell you that in advance so that you can prepare, to bring your own expert, or to at least anticipate the kind of questions. I would imagine that in a case like this, we'll probably be hearing from Ms. Nelson herself, maybe Laney Webb. I believe she was actually the operator of the vehicle as alleged.
Correct.
Mr. Webb, as the father, probably won't need to say anything unless there's a dispute about, whose title the name is in or something. But generally, we just want personal knowledge, actual knowledge of what takes.
I just popped the speed up real quick because I'm creating this live and I don't want to miss it. She deletes her things afterwards, but I also just want to do this in one take. So I got it up to 1.25, and that means if this is too fast for you, you can slow the speed in your YouTube video down to 0.75 and it will be 1. Okay, let's go.
Place. So number 4 here is about hearsay. And generally, hearsay is items in which you did not personally hear, witness, or learn it yourself. So if you wanted to say, the day of this alleged collision, a guy in a green truck told me that he saw me coming, that would be hearsay. That gentleman would need to be here to be able to testify to that.
Okay.
There are some exceptions to that. And I'd say if you go to texaslawhelp.org, they have good information about trials that's meant to be for pro se people who aren't attorneys. But that would be one thing. Generally, if you have, let's say you had an email from a week ago that said, or from 6 months ago that said something, that could come in as a historical record to prove that an email took place then. But what the email says, if it says another guy told me something, that is still hearsay. So there's kind of a way that we review what we're looking at.
Okay.
In a case like this, which is essentially a lawsuit arising out of a collision in which an insurance claim was filed and denied, the long standard rule is that you cannot bring up any talk about the insurance company involved in it. That we're supposed to, even though people probably know or may assume or may wonder about it, that's a separate contractual issue. So we don't bring up the insurance company at all. And so advising companies that, that I couldn't afford my deductible or that I just want them to have the insurance company pay, those would be impermissible statements to be made to the jury, either in your opening, in testimony, or in closing. Okay. So conversations about insurance are about who pays after the fact. And this case would just be about who's at fault for a collision.
Let me ask you a question, if you don't mind.
No, that's why we're here.
On the web said that I ran into Laney. And my insurance company, that's part of my evidence. They never did submit a claim either to Liberty Bell or to
That's not
mine.
evidence of anything, Ms. Nelson. That's what we're saying. The insurance portion is completely irrelevant to your lawsuit. You want to focus on establishing where you were, who was moving, and what happened. Anything after the collision occurred has nothing to do with who's at fault in that moment.
Even if they say I ran into her, wouldn't it be normal to file a claim?
No, again, Ms. Nelson, that's the reason we're doing this pretrial.
Okay.
Insurance methods are completely subjective. They have nothing to do with whether or not you can prove the defendant hit your car. Right?
Okay.
Whether or not someone has the ability to pay is irrelevant to whether or not they're at fault and should pay.
Okay.
So we can't bring it up. That's why we're doing this, because I run into this a
Good.
lot where it seems, but why wouldn't we? And you're not necessarily wrong in your logic, but the legal question we're asking stops at the moment the collision occurred.
Okay.
So things that happen after that, generally, especially when it relates to insurance, people can file insurance reasons or not for any number of reasons, and I won't even bother with that. But that's a good question, and that's the reason for it. So then, number
Thank
6,
you.
the idea about being a poor man. This is kind of the same thing. What you're going to be asking the jury to decide is, was the defendant at fault or more at fault than you in a collision? That's ultimately kind of the question that you're getting at. Whether or not someone has more money than the other, not important, and whether or not someone caused a collision in a car.
Okay.
So the ability for you to pay or her to pay, jury should not concern themselves with that. We know sometimes they want to, but legally, we're supposed to avoid it. So that's the reason for that. Stipulations, I'm not going to worry too much about that. Formalities. Generally, if you want to introduce testimony that requires a certain level of opinion or an expert opinion or a learned opinion, you have to establish a foundation. So if you say, that it was like a medical injury, lay people can't tell me about medical injuries. You can tell me about the pain you're experiencing, but what causes the pain requires a medical testimony. So that would need to be an expert witness. And again, that information gets disclosed both ways.
Okay.
Number 9, it's called the commit the jury. And this is actually a common thing that happens. You can't ask the jury to go ahead and decide while you're selecting a jury. So an example of that would be, who here agrees that we should legalize sports betting in Texas? Go ahead. Would you make a bet? You've been fantasy football. If everyone shakes their head that they find that race, that would be a way of trying to get the jury to commit to an answer before they've heard the facts. So when you get to do voir dire, and Ms. Nelson, this is a good time to explain that. When we begin the jury trial, the very first thing that both you and the defendant will do is get to question all 24 potential jurors. So we're going to set them in the courtroom in order, and they're going to be wearing a number, like a little clip-on number that says juror 1, juror 2, juror 5, juror 22. And we are going to give you a packet. For each juror, you're going to get a sheet of paper that explains who they are, what they do for a living, where they moved from, what their education is. The jurors must fill out a form to give you some basic information so that you can look through those potential jurors and see, do you think anyone here has a bias or something that might be in your favor? Do you just not like someone from that county or that city or that state? I'm not joking. I've seen very strange things asked. In a lawsuit at a football game, they asked about rivals. Would you be able to find in favor of a Longhorn if you're a strong Aggie? And I had someone in the back of the juror was like, I don't know. Might be trouble with that. So these are kind of, it sounds a bit, but that's what you're allowed to ask. What you can't do is say, if you were in a collision, wouldn't you want someone to pay for it? Because that starts to get into the committing of parts, okay?
I understand. Thank you.
But you do get to ask the jurors all types of questions. And so I would encourage both sides to think about what type of juror might you want to have on your trial, or who would you not want to hear it? Because these are the kind of questions that you can ask, generally yes or no questions to jurors. And then Ms. Nelson, you will get to if there's any juror who says they're not able to sit, maybe they know me personally, maybe they know you personally or the defendant, maybe they hate cars and they don't want to be involved in a car accident case, right? Sometimes we can strike a juror for cause. So of the 24 potential jurors, there may be one who is ill that day and cannot appear. There may be one who says they would not be able to hear this case because they know me, and we would strike them for cause. After we get rid of people who have a cause to not be here, you have your choice of striking, of getting rid of any 3 jurors that you don't like. And so does the defendant. So when you look at your jury pool, they'll be numbered, and generally the first 15 are more likely to be in your 6 jurors than numbers 16 through 24.
Okay.
Okay, so the first 6 jurors that aren't struck, that's how you end up with a jury. So think about that when you're coming to court, because Mr. Dunn went to law school. We had to take extra classes to learn all of this stuff. I don't find that it's common knowledge, Ms. Nelson, so you're going to be just fine, but I do think it's helpful to know that in advance, that you'll be given at least 15 minutes just on your own to ask any questions that you like of those jurors. And then you get to privately choose. You can keep them all, but if you see, I don't like that one juror, keeps giving me a dirty look, let me just strike them and be safe. And that's a valid thing to do. Yeah, go ahead, Ms. Nelson.
Can I ask if they know the Webb family, or have you already done that?
No, you should ask that. That's a standard question that we would ask. Do you,
Okay.
and generally we would ask the juror, do the jurors right now, the potential jurors, do you recognize me? Do you know me? Do you know the plaintiff? Do you know either of the defendants? And if they all say no, then we say, okay, fantastic. Voir dire begins. And generally, Ms. Nelson, Mr. Dunn, I allow about 15 minutes for a voir dire in a small claims case. If there's something specific that you think we need more time, I'm happy to allot it. I don't generally find that most people take it, probably because it's a little bit strange if you don't, again, lawyers, we went to get training for this. I don't know if it was good or bad.
Can I ask you another, you may not be able to answer this, but what questions would you ask them, advise me to ask them?
So I can't give you advice, but I can tell you that in general, you would want to ask questions to make certain that your jurors are going to be fair, that they don't have any preconceived notions that might interfere with the listening clearly to the case. That's probably as much as I can give you, Ms. Nelson. I'd say if you look into it, if you did a search for how to choose a jury, you're bound to come into a lot of questions and things that might give you a sense of, oh, okay.
Okay.
Right. So there's lots of these. You can also watch the internet in the meantime. Lots of cases we'll be doing these on the internet. You can juries aren't generally on Zoom anymore because they're just so hard to do that way. But I would again recommend texaslawhelp.org. That's the website, Texas Law Help. And that's a free website put on by the State Bar of Texas. So attorney fees pay for this website, and they've got great information.
Perfect.
Under small claims.
Okay.
Okay. Number 10 deals with undisclosed witnesses. Again, you don't want to surprise either side. So you can't say, hey, by the way, here's the truck driver, right? So you got to tell everybody who y'all plan to call as witnesses. Jury display, number 11. If you want to bring forth a demonstrative, let's say you want to have a map, a Google screenshot or a map or a drawn sketch of the layout of the parking lot or of the street where this occurred, you can do so, but you need to introduce those to us. So submit those to the court 3 days before trial, send a copy to the defendant. Mr. Dunn, same thing. If you have anything you're wanting to permit, I had an attorney just started drawing on the board with this one day and kind of had to stop and say, everyone okay with that? They were, but I'll do that in advance.
I have submitted a map of the parking lot. So they will have that, right? Okay.
We have, if you've already given it to us, we have it in the court record for it. It will be there in the file to be presented. But
Perfect.
This is to present people from kind of coming in the last day and, hey, here's my 3D model of something. It needs to be
Lord.
advanced. So
Okay.
that's what that one is. Not to make any demands upon the counsel before the jury. Yes, don't. Neither party should look to each other in the front of the jury and say, hey, give me those files finally. Do that outside the hearing of the jury, right? Or email the court and say, court, we asked for something and they've never provided it to us. And we need it in order to have our jury trial. 13 says that neither party should discuss the fact that we've had this motion or had this discussion about pretrial matters, because to tell the jury that we had a pretrial motion about things we couldn't discuss would just cause the jurors to go, well, what did they discuss that we can't hear? And the idea is that the jury should be sort of naively ignorant in some ways, just there for that little bit with the two of you. Okay.
I do have another question.
Absolutely.
So can I ask for their evidence to be sent to me?
Yes.
Okay.
You absolutely can. Y'all can exchange information. It's called discovery. You can send a request to us that say, I'd like Mr. Dunn to provide me with all the evidence or witness list that he plans to have. And that way you can be prepared, and same thing.
Okay. Just because I send it to the court, do they share it with him automatically or? Okay.
So if you make a request for discovery and you send it to us, we will review it to see if we can grant it. And if we grant it, then we would send a copy to both you saying we granted it and a copy to the defendant saying, I granted this. Here's the timeline y'all have to exchange information.
Okay.
Okay. In general, well, we're in small claims, so it's a little bit different of a timeline, but you'd want to give each side at least 15 days generally to try to respond to a request. So if you're
Can
going
can I ask you right now, Mr. Dunn, to send me evidence that you have a full discovery?
Your Honor, do you want me to answer? I don't.
Ms. Nelson, you can make that request, but you'll still need to put it in writing for me to sign it.
Oh, okay.
All right, but I think if y'all already have your exhibits, if you have any estimates, if you've had estimates of damage, I will just highlight that now. I had a case came before us all the way to the end of the jury, and the jury could not find in favor of one of the parties because no one put on evidence of damages.
That's been submitted to on my end.
Fantastic. That's just an important part to highlight for both sides. Because that was
When
we
you
got
say
all the way to the end, and the jury went, well, Judge, we don't know what to award. And I'm like, you're right. They didn't put on evidence of that. So, and both sides just kind of looked at each other and went, oh man, I'm like, that was a lot of none. So it happens. On page 3 here, the next section is that most of this is getting into whether or not you have already agreed to pay or agreed to pay a portion of it. Any attempts that y'all made to settle, just ignore those when you're in the trial, just as though y'all didn't have any of those conversations. So again, the jury is there just to decide who was at fault when a collision occurred. Everything after that, not really important for them to make that decision of who was at fault or who was most at fault in that moment.
Another stupid question, probably. When you say have to do it in writing, is an email, is that considered?
Yep, that'd be completely sufficient, Ms. Nelson.
Okay, thank you.
Again, if you go to that Texas Law Help and look up, what should I ask in discovery? You might get some ideas about specifically what you'd want to ask Mr. Dunn to provide.
Okay.
Okay. Number 16 is that neither party should mention if you're not calling an expert witness. I don't know that y'all would have any here. This is a collision. Is there any allegation of physical injury, or is it just to the cars?
Just the car.
Okay, no concerns about that one. Number 17 is that neither of you call as witnesses anyone who hasn't already been identified as having knowledge about it. So, for example, if you have someone who witnessed the collision, you would want to give that name of that person and their contact info to the defendant, and defendant at the same time, if they have someone they plan to call, should provide that to you if y'all ask for that information. And it sounds like you're going to, Ms. Nelson, so that information can be exchanged. That plaintiff's counsel not be permitted to mention damages other than the actual elements. This is true. So, Ms. Nelson, you can bring up and defendant can talk about your actual out-of-pocket costs. So if you have actually spent money to repair something, you could explain that. If you have an estimate to repair something, but you haven't paid it yet, that's okay. But you can't talk about if you've paid for ad bill or medical bills or injuries like that, because this is a case about property damage from the car and that alone. Okay.
I understand.
I don't think anyone here is issuing subpoenas, so 21 might just be standard language from all types of these, but I haven't received any subpoenas. And Ms. Nelson, you do have the option. Let's say there was someone who had witnessed this and you really wanted them to come to court and they, for whatever reason, were ignoring you. You can request a subpoena from our court to any individual with knowledge of a lawsuit, and that person would be commanded to appear in court.
Okay.
They may or may not, they can ignore the court's warning, but that might get them in further trouble. Most people do respond to a subpoena. You don't have to though. If you, let's say, your sister was in a car with you when the collision happened, you can just say, hey, sister, will you come to court? And she says, yes, say great. And then just tell defense counsel, my sister Jonas coming, or whoever. Okay.
Okay.
It's if it's someone else. You want to surprise that. Number 22, failure to call any witnesses or not. Same thing. Let's say your sister's in the car, but you don't call her as a witness. Defense counsel can't ask you why you didn't call her, and you can't ask them the same thing. Just focus on who is there, okay? You can mention that she was there, but you can't say, and they didn't call her as a witness. Why do you think that is?
Okay.
And he can't do that. The same is true for the defendant, right? So this is how it works. Both sides. The idea is that you can't try to put an inference in the mind of the jury as to why someone did or didn't do something, because really what we're asking them is what happened when the two cars hit each other. Was one person more at fault? And everything after that is the frustrating part, but not the question of law for us. All right. And then number 23, further, not mention the state probable testimony of the witness who is absent. And that's another one. So let's say I'm kind of making up an example that my sister was in the car with me. Let's say she's not there to testify. I can't say if my sister could be here, but she's, bless her heart, she's with our kids today. If she was here though, she would tell you that I was right and they were wrong. You can't do that either. That gets again into hearsay, and also someone who's not there to be properly cross-examined. All right. And that's it. Those are all the things that we have on the motion in limine, which I would grant those things. Those are all pretty standard requests. But Ms. Nelson, I know you're pro se, and Mr. Dunn won't be here, so it might be good for him to take notes for whoever associate counsel is that comes next as to why that was granted and then what were some of the requests on that. All right, so Ms. Nelson, with that, I think, unless there's questions from the parties, y'all both have time still if you're interested in taking a formal discovery. So Ms. Nelson, if you want to send us an email that says, here's what I'd like defendant to provide me, we can put that into a motion and grant it, and then we would send that to Mr. Dunn. And Mr. Dunn may probably not be the one to respond, but someone with the firm he's leaving, that law firm is responsible for the lawsuit. So someone there would respond. Okay. And then
Perfect.
if you have any evidence that you want to bring to court, you can submit it to us. You can send it to the defendant as well. And then when we come to court on that day of jury trial, we will have items in our documents already. But if you wish to bring anything with you, in general, you would bring 3 copies of any item that you brought. And the reason you bring 3 copies is that 1 copy would be given to the defendant, 1 copy would be given to the court, and 1 copy you could review, and we might give it to the jury. Okay.
Question: if I ask for a formal discovery today,
Mhm.
and then something pops up on their end, do I have to do another formal discovery, or whenever they get something new, do they automatically send that to me?
If what you've asked them to do is provide you with the documentation or the evidence or whatever you request, if the things you've requested, the new items fall within that, they should provide that to you because it's all a part of the discovery.
Okay.
If it's something completely brand new, it gets into an element of surprise, right? They generally, both parties should know what the other side is bringing to court.
Okay.
Because despite TV making it seem like there's a lot of last minute we run in with evidence, the truth is there's very little that we're not already aware of when we come to the trial. It's that, and the legal phrase is that reasonable minds disagree. Remember that picture of a dress? Some people thought it was white and gold. Some people thought it was blue and black.
Right.
Those were a reasonable disagreement until we got together and we all looked at the photo in real life and we're like, oh, look at that, it's purple. Right? So the idea is that y'all will have already seen your photos, your evidence, the names of the witnesses who'll be there. You probably even anticipate what they're going to say. It's still how the jury listens to it and what they take back and then reflect. The other thing, Ms. Nelson, that you should be advised about is that because defense counsel has an attorney, they may bring with them what's known as jury instructions or questions to submit to the jury. And this is something that we would review as a group, you and me and defense counsel, and we would submit this. But when the jury goes back to deliberate, you'll have 6 jurors. They'll have heard all of your information, your testimony, the defendant's testimony, witnesses. We must give the jury a list of questions to answer to decide who's winning. So, who did you find to be at fault? Do you find the plaintiff to be 51% or more at fault? Do you find the defendant to be 51% or more at fault? If you find the defendant to be 51% or more at fault, what percentage of that do you assign? What do you find damages to be? How much of that would you give to the plaintiff, if anything? But there will be a pattern of questions. It's called a jury charge. And so you might already kind of be thinking, what is it I'm trying to prove? Is it an amount of money? Is it just liability? I imagine you're trying to prove an amount of money and a damage. And then how will you show that? If they agree that we're not at fault in the collision, how will they know what money to give you? Will you have an exhibit for that? Defendant may bring their own, say she's brought exhibits to say it's worth $5,000 and we disagree. Our exhibit says it's worth $3,000. Then the jury may come up with, we tell them they can't just make an average, but I've seen all strange things with jurors. So the jurors will come up with their own numbers.
My estimate from the dealership, that would suffice, right? As
it is evidence. I can't say if it'll suffice. I'm saying that if you have an estimate for a repair from a dealership and it's on its face, otherwise proper, it would be admissible. And then the jury can do with it what they want. If they think that's a good estimate and that you should be entitled to damages, they could award it. I cannot tell you what a jury will decide. But reliability of the evidence, how it came to be. This is where I think that Texas Law Help website may be good for you to review, Ms. Nelson, how to prepare for a small claims case on your own.
Thank you so much.
Absolutely. That's our goal here, right? The cases are their cases.
Are you going to be there? Are you going to be at the jury trial?
I should be here on the 28th of April. Yeah, so it might quite be. It might be a visiting judge, but I try to do all my juries.
Okay, awesome. Thank
Mr.
you.
Dunn, what was your question?
I just wanted to help the pro se plaintiff. I know on my side, let's say you ask for something, all the evidence that we have to defend. We have what's called a continuing duty. So if something new were to come in, then we have a professional responsibility to provide that to you. I think that kind of answers the question you had earlier.
Absolutely.
Yes.
Yeah.
But only the things that you asked and were approved, if that makes sense.
Yeah. So Ms. Nelson, the example there is if you said, give me all of your red folder documents and they got a new blue one, they don't have to give you the blue one. But if you said, give me all, but if you said, give me all the blue documents and they got a new blue one, they'd have to send you the new blue one. So the way you ask for your discovery puts the duty on them about what they must keep getting. Now you can't say, give me every document you've ever received because not all documents are related to the case. So
what should I ask? And
I'm not able to tell you that. That would be getting into legal advice, Ms. Nelson. But I will say, again, I think that website, another resource is the Travis County Law Library. They're downtown. It's free. They have real lawyers. They can give you information too about how to prepare for your small claims case.
Okay.
And then the last thing I'll mention, because this is one, Mr. Dunn, I don't find most people know, Ms. Nelson, because you're the plaintiff, you have what's called the burden of proof. The defendant can literally sit there and be silent, not say anything, not talk to the jury, not ask any questions, not make a statement, just be silent. And if you don't meet a threshold level of proof, the case is over.
Okay.
So that's because you're the action. Now, as the plaintiff in a civil lawsuit, you can call to the stand any witnesses that you bring and the defendant. You can call the defendants as a witness in your case. You do
Okay.
not have to wait for them to do it.
Okay.
Most people don't, Mr. Dunn. I advise this because I do not find that many people realize this. Most people are familiar with criminal cases where you have a right to be silent. That's not the case here. So, Ms. Nelson,
Right.
in your lawsuit, as part of your case, you can call to the stand Lainey Webb and Robert Webb if you think they have personal knowledge about it. Right. Now, again, I don't know what Mr. Webb might know about it. If he's only there because he's the owner of the car and has the insurance, he's probably just a necessary party but has no real information.
Right.
Right.
It's just me
Ms.
and Lainey.
Webb, if she was operating the vehicle, you can call her. And then the other thing about that is that when you're the person who's calling a witness, when you're testifying on your own, and when you call a witness, you can only ask them open questions, meaning, what day was it? Do you remember what time it was? Do you know what color your shirt was? You can't ask what's called a leading question. Wasn't your shirt red? It was 2 p.m. Was that right? It was a cloudy day. Isn't that correct? If you suggest the answer, you're leading. You can only lead people on cross-exam. So, for example, if you call yourself and you testify about what happened, Mr. Dunn or the attorney from their firm, they can ask you questions like, isn't it true that there was a rainbow in the sky that day and you were distracted? You could say no, but you can't ask that of Ms. Webb. You'd have to ask Ms. Webb, and were you distracted that day? Did you observe anything in the sky? Does that make sense?
Okay.
So I just want you to be prepared for that, because that comes up a lot, and there may be if there's a little bit of latitude that we can give it, but if you ask a lot of leading questions or try to suggest an answer, they're probably going to object, and I want you to be prepared for that. What is that difference? So open questions are what you can ask of the person you call, but if someone else calls the witness, then you can lead them all day long. Okay.
All righty.
All right. I think those are the 2 big ones that I encounter, is that people don't realize they can call the other side to come to the stand. But when you ask them questions, if you've called them, it's got to be open. You got to leave the question open for them, right?
Okay.
Okay.
What happens with perjury when you know that somebody's lying?
You have to prove it with evidence.
Okay.
So that's generally, we call that impeaching the witness. For example, if I said, I know that it was rainy that day, and they say, well, here's the national weather forecast from that day. Here's the local weather reports. All of them show that it was sunny and 90 degrees that day. Are you sure? Can you recollect now? Do you want to refresh your memory? And generally what happens with perjury is the jurors will decide, do they think this witness now has veracity or honesty? And if you have impeached a witness or proven that they are lying, or you've made it clear to the jury that you don't think they're being honest, the jury will take that in their determination of fact. They get to decide our credibility of the witnesses.
How do I phrase that? I don't think you're being honest. I think you're lying.
You can't say it like that, because that's your opinion. If you think they're lying, you have to have evidence to prove it. You said it was sunny, but the weather report says that's not true. Yeah. Because it may be that you are the opinion, and both of you are opinionated, and the opinion is wrong. That doesn't mean they're lying. And that's a strong way to put it.
Yeah.
So if y'all agreed, we wouldn't have a lawsuit, right? So there must be some level of disagreement. People can be incorrect. My example of the white and gold versus blue and black dress, people were adamant about it.
Yep.
But it's so instead, if you believe someone is misrepresenting, the way to show that is to either with your own testimony, what did you see that day, or if you have evidence. Here's a photo. You said you didn't see it, but in the photo it's visible, and then the jury can decide. Well, I'd have seen it, right? So in a lawsuit like this, the judge, my role is to tell the jurors what the law is. Yes, that's a law. No, that's not against the law. Yes, you can award money for that. No, that's not a recoverable thing.
Okay.
But they decide on the facts. So once I tell them that if you find it's true that A and B equals C, then they have to decide if you've shown them that A and B existed to get to C.
Okay.
Okay.
Perfect.
All right. Any other questions?
No, I've had too many. I apologize.
No, you haven't, Ms. Nelson. That's why I set this for a pretrial, because Mr. Dunn made a valid motion. I'm going to grant it. We have granted it, but I understand that it's a lot of legal language, and I took out loans to learn this stuff, right?
Yeah.
So you involved in a collision and just trying to recover something. So very, very different. All right.
You've been very pleasant.
Well, we try to be. Our job is, I have no stake in this, right? I'm the very top level of it. All right. Well, Ms. Nelson, if you make your written request to us via email, we'll certainly review them. We would send them to defense counsel, and y'all can continue in that vein. Mr. Dunn, I may not see you again in this capacity, so good luck to you. All right.
Thank you, Your Honor.
Thank you. With that, all parties are excused. Y'all have a good afternoon.
Thank you.
Thank you.
Bye-bye.
Well, thank you, Judge Y'all, for that excellent explanation of how things seem to work in Texas. Hold on one second. as I get rid of that, I swear. Anyways, I love how she explains things. I think she toes the line between, advising people with legal advice and just giving them, you know, help or whatever. But, anyways, I thought you guys would enjoy that. Let me know what you think down below. This is obviously a different experience from her than yesterday, which we watched her hold somebody in contempt of court. But I would love to hear your thoughts down below about what you think of Judge Y'all. All right, guys. Thanks so much for tuning in. I will check in with you later. Bye.